Good afternoon and welcome to the Office of Economic Development Business Information Session. My name is Margaret McGee, the Business Services Manager. Business services assist entrepreneurs and business owners in starting and growing their business. We help in navigating through the different departments within city government to obtain permits and licenses. We also connect the business community with organizations that can provide technical assistance, incentives, resources, and other beneficial programs in operating a business. We host business information sessions throughout the year, and topics are gathered from entrepreneurs, surveys, and information we collect from the business community. Today we have Ms. Elizabeth Daltrey, the United States Patent and Trademark Office Southeast Regional Outreach Director. We also have Ms. Samantha Levin. She's an attorney advisor with the U.S. Copyright Office. To keep down distractions, attendees, please turn off your videos and mute your speakers. Please place your questions in the chat box and they will be addressed when the time allows. All handouts provided to me will be shared within 24 to 48 hours after the meeting has ended. Now I'll turn it over to Ms. Elizabeth and Ms. Samantha.
Well, thank you, Margaret. Thank you for having us here today. It's a pleasure to engage with you, your clients, this audience, who I'm hopeful are eager to learn more about the role and importance of intellectual property. Today, myself and my colleague will be talking about patents, trademarks, and copyrights. What does that mean? Why is it important to you, particularly as a small business owner? I'm going to look to my federal colleague, Samantha. Samantha, would you like to go first?
Sure, I would be happy to. And
Okay,
Elizabeth, thank you for the great introduction there.
you let me know when you're done and I'll jump back in. But otherwise, I'll turn off my camera until that time.
That sounds great. So as Elizabeth mentioned, and as Margaret mentioned, my name is Samantha Levin, and I'm an attorney advisor with the United States Copyright Office, specifically in the Office of Public Information Education, as we call PI to shorten. But let me pull up our presentation and we will get into it. We're very excited to be here today and to discuss how copyright plays a role in small businesses and in the small business industry. So everyone should be able to see the slides now. If you can't, please let me know. But again, thank you for joining us to learn more about how the copyright system supports small businesses. And we will also share helpful free resources that the United States Copyright Office provides. Again, my name is Samantha Levin, and I am an attorney advisor in the Office of Public Information Education, again, also called PI, at the Copyright Office. And along with my colleagues, I frequently participate in outreach projects like this session, and we enjoy explaining copyright law to the public. We are absolutely thrilled that so many people want to learn about copyright in small business. And I'd also like to introduce my colleague, Taylor Schumacher, who is also an attorney advisor in PI, and she is here today, but I will be providing the presentation. So today we'll discuss what small business owners should know about copyright. And no matter what industry you're in or what product or service you provide, copyright is a tool in your toolbox that you should be aware of. And during today's webinar, we'll lay the groundwork of what the Copyright Office does and also the basics of copyright, especially as it pertains to small businesses. We'll also spend a few minutes discussing the registration process and what to keep in mind when applying to register your work. So let's start with the key takeaways, the big questions. Why is copyright important for you and your business? Let's discuss how copyright law applies to you as small business owners, as well as the products and services you provide, and why exactly copyright matters to you. The big picture here is that copyright gives you the tools you need to use what you create, those works that you create, in the ways that you want to. It also provides rules for others to follow if they want to use your works, such as through contracts and licenses. And ultimately, copyright is designed to incentivize creation and support you and your rights in the works that you create. So I wanted to take a big step back. We've discussed how copyright at a large scale is relevant to small business, but also let's look at intellectual property or IP in general. And this image, taken from our toolkit, which I'll talk about more later in the presentation, shows you how copyright and intellectual property, or IP, is all around us. And here we have a common scene at a desk where we can show how copyright protects the cat sculpture, the books, the artwork, the photographs, and the music, for example. And ultimately, IP protects creations of the mind, and copyright is just one type of IP. So we'll cover copyright in depth today, but at a basic level, it protects the expression of an idea, which means the exact words or form, such as visual or musical form, chosen to convey that idea. And Elizabeth will talk more about trademarks and patents, but just to set the stage there, trademarks, again, another type of intellectual property, help consumers identify the source of what they're buying or using, especially essentially creating brand protection. Trademark protects words, names, and symbols, and the objective is to prevent competitors from creating a confusingly similar mark on products or services in that same category. Patents, on the other hand, protect inventions and discoveries, ideas, processes, methods, concepts, machines, and devices, including new plant species. And you can see that in the graphic here with the little symbol next to the cactus. There's also trade secret law, which protects economically valuable information like data, recipes, and formulas. I'm sure that you can think of a few formula and recipes that are trade secrets. And these are kept secret, and that's where that protection is drawn from. And again, the Patent Office, the USPTO, the Patent and Trademark Office, administers our patent and trademark laws, and the office that I am in, the Copyright Office, administers copyright law. So now, let's talk more about the Copyright Office and what we do. In 1870, Congress centralized the nation's copyright registration function within the Library of Congress, eventually creating the Copyright Office as its own separate department. The Copyright Office is charged with administering the Copyright Act, and we're located in Washington, D.C. on Capitol Hill. This year is a banner one marking the 50th anniversary of the Copyright Act of 1976, which overall is the act under which current copyright laws are derived from. The Copyright Office is open to the public, and you can schedule tours and see the Find Yourself in Copyright exhibit, which explores how US copyright law has evolved and how the millions of copyright claims registered with the office illustrate the varied nature of original works. So if you're local to the area or visiting at any time, you can come by, you can see the exhibit, you can schedule a tour, and there's also an opportunity to visit the Public Information Office in person, which I'll get into a little bit later. And thank you so much for your questions. I will get to the questions at the end of the presentation so that I can give them my full focus and be able to have a conversation there. So, as I mentioned, the Copyright Office administers copyright law in the United States. Our mission statement is to promote creativity and free expression by administering the nation's copyright laws and by providing impartial, expert advice on copyright policy for the benefit of all. We have a small but mighty staff of about 450 employees, and we all have many responsibilities. First, we make and maintain the records that provide details on copyright ownership, which includes registration, which you may be most familiar with, but also recorded documents about transfers of ownership, which you will probably also find to be especially relevant. We also administer statutory licenses, develop regulations, advise Congress, and participate in the international copyright community. In the top photo here, the top photo, also the bottom right, you'll see us providing information to the public, which is central to the work that we do as part of the public information and education team. So we also attend events with our tabling and serve as panelists at different events. Congress has delegated authority to the Copyright Office to develop regulations concerning many areas of copyright law, and the subjects of these regulations cover a wide range of topics. These regulations provide the public with a well-functioning copyright system. So let's get into it. Now that you know a bit more about the Copyright Office, we can discuss the basics of copyright law. So to give a bit of a historical background to how copyright law came about, it actually first began in the US as part of the Constitution. And present day, copyright protection arises under federal law, specifically Title 17 of the United States Code, but we just call it the Copyright Act. And the Copyright Act tells us that copyright protection exists in original works of authorship that are fixed in a original tangible medium of expression. And those are the three components required for copyright protection: work of authorship, originality, and fixation. And these set the threshold for what is eligible for protection. And just to set the stage here, you'll hear me talk about authors in copyright law, and that means any type of creator, whether it's an individual or an entity, and it doesn't necessarily mean an author of a book or someone who writes something. It means the creator in all different areas of works. So we just said a lot about what can be protected under copyright law, and I'll break that down into some more digestible chunks. So first, originality in copyright involves two components. The first is independent creation, and the second is sufficient creativity. Independent creation means that the work must come from the author and not be copied from another work. And creativity means that the work must create and contain at least a small amount of creative expression. And that small amount must be more than trivial. This requirement also means that copyright does not protect ideas, facts, or common elements like individual words, but rather the author's expression of these things, such as when a writer combines words to create website content. And just because copyright law does not protect this list of things that I just mentioned, that doesn't mean that there aren't other areas of law that may provide protection. So here's an example of what may not meet that sufficient creativity threshold. If an author cuts 2 seconds from a pre-existing film and submits a registration application for the editing, that will probably not meet the threshold for creativity. Next, work of authorship means the type of creative expression. So in the business context, that would include things like photographs on your website or instructional materials about your product. And finally, fixed means the work must be captured in some stable form that can be perceived or copied, like when you write it down or record it. For a small business, that could be a manual saved as a PDF file or advertising music saved as an audio file. Until a work is fixed, it is not protected under copyright law. Excuse me. Copyright protection begins the moment a work is fixed. There are no formalities like including the C in a circle symbol you might see on the inside page of a book, along with the year of the work, but this information can be helpful, and I'll get into why in a little bit. So we talked about what types of works can be protected by copyright law, but what kind of things can a copyright owner do with their works? The Copyright Act covers a copyright owner's exclusive rights to reproduction, creation of derivative works, distribution, public performance, and public display. The Act also includes the rules for how a copyright owner can authorize others to exercise these rights. For example, the copyright owner of a book has the exclusive right to create copies of that book, reproduction, and to create derivative works based on that book, such as a sequel or movie adaptation. But what is important to keep in mind is that a copyright owner also has the right to give someone else permission to do those things, as we mentioned, such as through a license contract. Next, let's discuss examples of works of authorship. As we mentioned, the term works of authorship means the type of works protected by copyright, and it isn't limited to books. Here are the broad categories of works of authorship, which are literary works, musical works, dramatic works, pantomimes and choreographic works, pictorial, graphic, and sculptural works, motion pictures and other audiovisual works, sound recordings, and architectural works. And it's important to remember that copyright can only protect material that is the product of human creativity. So when we say authorship, we mean human authorship. Here, we have some examples of works of authorship that you, your employees, or your company may create during your day-to-day business activities. Everything from advertisements to commercials to promotional materials and business manuals, as well as deliverables for clients, may be protected by copyright law. So we discussed this briefly, but it's important to also know what copyright does not protect. We discussed a few examples, but let's talk about it a bit more. So when we talk about what copyright does not protect, it's important to remember that copyright is designed to protect creative expression without locking up what we'll call certain building blocks that allow others to advance the progress of science and the useful arts, as said in the Constitution. But basically, reminder that some of these unprotected elements may fall under other areas of law. For example, certain design processes or functional innovations might be eligible for patent protection, which has different requirements and limits under US law, and Elizabeth will get into that in more detail, I'm sure. And just a reminder that copyright and patent law are doing different jobs, even though they sometimes overlap in the IP ecosystem. As well, it's important to remember that copyright protects your actual expression, not the idea that is underlying behind it. As an example, no one can copyright an art style. No one owns cubism, surrealism, illustration, or minimalism, for example. Even if your work is instantly recognizable, copyright doesn't give you ownership over the style itself. What it does protect is potentially your specific drawing, painting, sculpture, or digital file. And again, you can't copyright ideas or concepts. The idea of a portrait, a landscape, or a character with certain traits isn't protected, but the specific way that you render that subject or the choices you make about composition, color, and detail may be protected. So we talked about what copyright law protects, and we know what cannot be protected by copyright law, but who owns the copyright in a work? The copyright in a work initially belongs to the author or authors in some cases who created that work. And again, as with works of authorship, when I mention author, I don't mean someone who wrote a book, I mean any type of creator. But let's talk about how this works in business, especially if multiple people contribute to a work. So, under certain circumstances, especially when people intend to create a work together, the result is called a joint work. In that case, each author has an ownership interest, which is important to remember if you're looking to enter into a license or sales agreement. What's important to keep in mind is that this means one joint author does not need the other joint author's permission to decide how to use the work, including in deciding whether to allow others to use the work. And as you can imagine, this can get a bit messy. But it's important to remember that if one joint author makes any of these decisions, they must share any royalties or profits they receive with all of the other joint owners, unless there's an agreement that says otherwise. In business especially, there are situations where the author is not necessarily the copyright owner. You may have heard the term work made for hire. And with a work made for hire, the employer or commissioning party is often the copyright owner rather than an employee or independent contractor, for example. But it's important to note that this isn't a hard and fast rule and depends on the specific situation and business relationship. So we've now talked about the elements required for copyright protection and who is likely the copyright owner of a given work, but we also need to discuss how long copyright protection lasts. In general, under the current law, a work's copyright lasts for the life of the author plus 70 years after the death of the author. After that point, the copyright term expires and the work enters what we call the public domain. If a work has multiple authors, copyright protection expires 70 years after that last surviving author dies. However, this can change if the author is identified under a pen name or is anonymous. Here, the copyright expires either 95 years after the work is published, which is a term of art under copyright law, or 120 years after the work is created, whichever occurs first. And going back to work made for hire, the same rule is followed. Copyright protection expires 95 years after publication, or 120 years after creation, whichever occurs first. So the way a work is created and published can have a big effect on the length of duration for its copyright protection. At the Copyright Office, we often talk both about copyright ownership and exclusive rights, but also how to be a responsible user of copyright protected materials. So if you're looking to use others' work, one option is to use materials that are already in the public domain, where copyright protection has expired. Another is to research ownership through resources like the Copyright Office's public records system, which can help identify the relevant rights holders and who to contact for permission to use that work. Other than obtaining permission and a license directly from the copyright owner, there are also licenses that operate by law. And these are called statutory licenses or compulsory licenses. And many of these apply specifically to music, which is especially complicated, as I'm sure you've experienced. And we at the Copyright Office have a lot of resources if anyone has questions here. Next, let's discuss registration basics and some details that are particularly relevant for small businesses, including why registration is beneficial to your business. So, how does a small business get their work registered? Let's start with some highlights of the copyright registration system. First, as we mentioned, copyright protection is automatic upon the creation of a work, but it does provide additional benefit to register your copyright, and we'll discuss those in a moment. Second, copyright registration is done only with the United States Copyright Office. Registration with the Copyright Office is the only way you can receive those additional benefits from copyright registration. For example, a registration with the Copyright Office is required for enforcement of your exclusive rights, either in court or the Copyright Claims Board. And third, there's no renewal or re-register requirement for copyright protection. You can consider copyright protection one and done. Another benefit is that registration creates a public record that includes key facts about your registered work. And this can include the name of the author and also the owner of the work, the title, the year the work was created, the year the work was published, and the date and nation of first publication. The public record tells others that you are the copyright owner for your works. And along these same lines, the registration record may also provide the name and contact information for the person or organization who can field requests from those seeking permission to use the work. So by providing this information in your registration record, you're making it easier for others to find you. Importantly, Registration is also a required component if you find yourself in a copyright dispute and would like to access federal court or the Copyright Claims Board. The Copyright Claims Board, in case you aren't familiar, is a three-member tribunal with the Copyright Office that resolves copyright disputes with up to $30,000 in damages at issue. If your work is infringed, it must be registered with the Copyright Office, or the Copyright Office must have refused registration in order to file a copyright infringement lawsuit. And if you file a claim with the CCB, or the Copyright Claims Board, you must first, one, have a registration from the Copyright Office for that work, or have submitted an application to register the work either before or at the same time you file your claim. And let's talk about some of those registration logistics. If you're interested in registering your works, you can give yourself a head start with this information before you start your actual application. First, you can ask yourself, what type of work do I want to register? Is my work published or unpublished? And again, publication has a specific definition here that guides which registration form you use, along with other aspects of copyright protection, some of which we've discussed. And you can also ask yourself, how many works do I want to register? Most applicants will find the standard application to be the best choice for their needs, but there are other options relevant to small business owners. For example, if you take a lot of photographs for marketing purposes, you may be interested in the group registration of unpublished photographs, which allows you to register up to 750 unpublished photographs for a single fee. Or if your business focuses on blog content, for example, you can look to the group registration for short online literary works to register up to 50 online literary works for a single fee. And these literary works must be between 50 and 17,500 words and have first been published as part of a website or a blog online platform. Or maybe you focus on advertising or training materials and write a lot of copy. Here you can consider the group registration for unpublished works, which can be used to register up to 10 unpublished works for a single fee. We discussed some of the features of these group applications, but there are additional eligibility requirements for each type of application. Now that we know our options for applying for a copyright registration, there are just a few more things to keep in mind before you're ready to file your application. You can choose your application type and submit your application online. Here is some key information. The online application process is much faster than filing by paper. You'll also need to submit a deposit, and that means the work itself or a copy of the work. For example, this can mean a PDF file or a sound recording, usually as an MP3 or WAV file, depending on the type of work you're looking to register. You'll also need to pay a fee to complete your application. This fee depends on the type of work and how many works you want to register. And as we discussed in the last slide, the Copyright Office offers group registration options as an efficient and cost-effective way to submit a single application for more than one work. So, how can the Copyright Office help you? We understand that this is a lot of information at once. You can find this information on our website at copyright.gov. We're also here to help. Our Public Information Office offers a variety of resources, and we'll have a slide with more details on that towards the end of the presentation. And now I want to highlight some of those resources that I mentioned. We have information at the Copyright Office in a variety of formats, including through our Learning Engine videos and Copyright Essentials webinar series. The Learning Engine videos introduce copyright concepts and the Copyright Office itself to those who may be new to a topic or who want to learn more. More videos will be added in the future on copyright.gov and to our YouTube channel. You can subscribe to the channel to be notified when new videos are available. The Copyright Essentials webinar series explores what you should know about copyright. Sessions are tailored for various types of creators in a variety of professions and industries. We discuss the basics of copyright and registration, review the types of works that copyright covers, and explain copyright myths, and share answers to commonly asked questions. And you can sign up to be notified about future Copyright Essentials webinars, and I will drop that link in the chat in case you are interested in signing up. These sessions go into a deeper dive than what we're talking about today. We've also developed a range of written materials to support authors of all kinds. And one of these resources is the Office's circulars, which are numbered one-pagers on individual topics and copyright. And these circulars are available online and I believe extremely helpful. They're one of my favorite resources that we offer. We also have a variety of handouts addressing specific topics for small businesses, and especially we have one called What Small Business Owners Should Know About Copyright. So I'm very much looking forward to Elizabeth's presentation, and it has been a pleasure to present together today. The Copyright Office also collaborates frequently with the Patent and Trademark Office, and we recently published a copyright registration toolkit as a companion to a resource from the Patent and Trademark Office. They have a toolkit as well that I'll leave to Elizabeth to describe. The copyright registration toolkit was designed with small businesses and their advisors, including legal advisors, in mind. It contains information that's helpful to small business owners who might be learning about copyright for the first time, or for those who've been registering their works with the office for decades but want more insight into the process. Please download, read, and share, and I will leave the slide on the screen for a few moments in case you'd like to make use of that QR code. And again, we're here to help. You can use the contact form on the website, copyright.gov, to request assistance on a variety of topics, including to request a walkthrough through an application for copyright registration. You can also call the Public Information Office directly using the phone numbers on the slide. The contact form is available on our website, and you can also use the QR code in the corner of this slide to get there directly. And I will leave that on the screen for just a few more moments in case you'd like to make use of that QR code. And thank you again for your time today and for being such a fantastic audience. Please follow us on X and LinkedIn for updates from the Copyright Office. You can also subscribe to our Newsnet and choose what kind of announcements you'd like to receive from the Copyright Office, whether that be about our blog, events, or legislative updates. And thank you again, and I'll turn things back to Margaret.
Thank you so much. Of course, that's a lot of information. Thank you so much for providing those links. I'm pretty sure everyone will definitely find that useful. So now we'll go ahead and turn it over to Elizabeth.
Well, thank you, Margaret. I'm excited to jump in on the heels of a really robust, exciting presentation on copyrights. I always learn something in listening to my federal colleagues from the U.S. Copyright Office. And it's exciting that we have the opportunity to speak side by side today because intellectual property does go hand in hand for business owners. Um, in many, many instances, people are creating what we call an intellectual property portfolio as they start and grow a small business, because you may be undertaking and creating a multitude of types of intellectual property needing protection. So I am going to jump into my slide materials and we are going to talk about patents and trademarks. So with that, let's jump right in. Again, we're going to talk about the intellectual property fundamentals of patents and trademarks because I am here representing the U.S. Patent and Trademark Office. So what are we going to touch on today? Again, the broad overview topic of what is intellectual property. And I know Samantha's already presented that, particularly in that really clever portrayal of how we are surrounded by intellectual property, no matter what our setting. So who is the U.S. Patent and Trademark Office? What are the roles of patents and trademarks in business? And what are some of the fundamentals of patents and trademarks? Now, you may be sitting back and thinking, intellectual property or patents and trademarks, why should I care? I'm no Albert Einstein. I'm not creating the next great widget, but you may be creating intellectual property without even knowing it. More importantly, and I think Samantha alluded to this, we are all not only users of intellectual property, we are all creators. So it's important that we not only protect the intellectual property that we are creating, either through a patent, a trademark, a copyright, or a trade secret, but that we also be respectful of the intellectual property of others, that we license, we seek permission to use, that we not just grab things off the internet and think that they're free, that we do our homework and behave appropriately with respect to others' intellectual property. So, for those of you who are new to the concept of intellectual property, you may be saying, why is it even called that? I've never heard of intellectual property. Well, let's just boil it down super quickly, and that is to say that intellectual property is not so different than real property. We're all probably pretty familiar with real property, whether it's a house, a car, a boat, some type of tangible property that we can buy, we can lease, we can assign to our heirs, we can give away freely. Intellectual property is similar in those same respects. It can be bought, it can be licensed, it can be given away, it can be assigned to our heirs, and it has value, just as our real property does. And in certain instances, for a business or an individual, your intellectual property might be the most valuable form of property you have in your business. And I hope that'll become evident in our conversation today. So, who or what is the U.S. Patent and Trademark Office? Well, I know Samantha shared with us that the Copyright Office began its work in 1870. Well, I'm going to dial back a little bit further in history for the U.S. Patent and Trademark Office because we began our work with the language of the Constitution. And actually, in fact, copyrights did as well, because in Article 1, Section 8, Clause 8, which is known as the Patent and Copyright Clause, our founding fathers decided that it was going to be important for us to grow as an industrialized nation, that we protect the writings and discoveries of authors and inventors. And we have done that ever since the inception of our nation. So the U.S. Patent and Trademark Office is none other than America's branding and innovation agency. We began our work with the first U.S. patent issued in 1790, and we have issued nearly 13 million patents since that time. We're headquartered in Alexandria, Virginia, but have regional offices in Detroit, Dallas, San Jose, California, and also community engagement offices located in a number of other cities across the nation. In my role as the Southeast Regional Outreach Director, I get to engage with stakeholders like yourself in the 9 states of the Southeast region of the United States. So again, the U.S. Patent and Trademark Office, we issue U.S. patents and we federally register U.S. trademarks. Now that's going to be important to know because there's also another nuance to trademarks that we'll talk about here shortly. So why is intellectual property, patents, trademarks, copyrights, and trade secrets important for you as a small business owner? Again, it goes back to that concept that IP, intellectual property, can provide value to your business. It makes it attractive to investors and buyers. Think about those conversations that happen on Shark Tank. It can deter infringement lawsuits by placing people on notice that this is your intellectual property and they need to talk to you and get your permission or potentially pay you to make use of it. It can increase your leveraging power. It is a property right, just like real property, and it is global in the sense that there are intellectual property systems that cover the entirety of the globe. Now, with that said, intellectual property rights are territorial and protect you only within the country or region that issues you that right. So let's jump right into patents. We're going to jump into the exciting stuff. So what is a patent? Well, a patent is the right to exclude others from making, using, selling, offering for sale, or importing the claimed invention for a limited period of time. So patents do not have an endless duration like copyrights. They exist for a limited period of time, and after that limited period of time, the invention becomes part of the public domain for anyone to use, make, sell, offer for sale, or import without the owner's permission. But during that period of limited exclusivity, the owner of that right has the opportunity to enjoy the benefit of their invention. Now, whether their invention is a new bicycle, a new toothbrush, or a new mousetrap, it doesn't matter. There are different types of patents, and we're going to talk about that in just a second. But as I said, patents, like all intellectual property, are territorial. So types of patents. Let's keep in mind there are three basic types of patents. Utility, which protect any process, machine, article of manufacture, composition of matter, or any improvement thereof. This is the bulk of what we think of as patented technologies. So again, whether it's a toothbrush, a cellular communication device, a new composition of matter, a new pharmaceutical, protected by utility patents. Utility patents have a duration, a lifespan of 20 years from the date of earliest filing. So if you were to file your patent application today for your great new mousetrap and you were to receive a US patent, well, it would be good for 20 years from today. Now, there are also design patents which protect the ornamental appearance of an article of manufacture. They are good for 15 years from the date of issuance. Now think about something like a cellular communication device. One simple, not so simple, cellular communication device might contain hundreds, if not thousands, of patented technologies, from the circuit design, from the glass, from the camera, from the ornamental appearance, the shape of that phone, protected by both utility and design patents. So oftentimes utility and design go hand in hand, and oftentimes an article of manufacture will be protected by both of those types of patents. And then last but not least are plant patents, which protect any newly invented strains of asexually reproducing flowering plants, fruit trees, or other hybrid plants. Think of poinsettias, rose bushes, fruit trees. Really fun stuff. And those are good for 20 years from the date of filing, like our utility patents. So what are the hurdles to patents? Because I'm sure those of you who have heard or contemplated seeking a US patent are very fearful because you've heard it's complicated, it can be expensive. Well, those are possibles because there are a lot of laws and rules which govern US patent practice because it is the federal government granting you a right. But what do you need to know? You need to know that when an examiner, a US patent examiner, and we have 9,000 of them, trained engineers and scientists who pick up your patent application, they are going to look to determine if your invention is novel, meaning never heard of before. Is that technology so new that it doesn't exist? Is it non-obvious, meaning that it is not an obvious variation on an existing technology? And does it have a utility? Does it have a useful purpose? We don't patent, things that don't have a utility. So these are going to be the basic analyses that the patent examiner conducts when determining and looking at your patent application. So what is not patentable? You cannot patent a mere idea. You must be in such possession of your invention that you can describe it with such specificity in your patent application that others can make and use your invention. So it can't just be an idea. You have to be in possession of how to make and use that invention. You cannot patent natural phenomena, and you cannot patent abstract ideas. So what does the path to a patent look like? Well, it usually starts with a new idea, and that new idea is generally because someone is trying to solve a problem, whether it's a problem they're experiencing, someone in their family, someone in their community, or perhaps people across the globe. Whether it's the need to purify water or the need to have clothes come out cleaner, these are all problems to solve. Now, you have the opportunity to file what is called a provisional patent application, not required by law, but it is a one-year placeholder you can use for a lower cost of entry and a lower barrier of entry to get your foot into the door with the USPTO. Now, you do, if you want to receive a US patent, need to file a non-provisional patent application because that's what's picked up by a US patent examiner and examined and can result in a US patent. So as I said, there is something called the provisional patent application, which is a useful one-year placeholder, lower cost of entry, lower barrier of entry, but not examined. but it allows you to use the term patent pending and have something on file with the office. So if thinking about going down the road of getting a patent, talk to your patent attorney, patent agent, or an IP professional about the concept of a provisional patent application. Now, what is the path to a patent, so to speak? Well, I will say it's a process of communication and collaboration with the U.S. Patent and Trademark Office. There's going to be a lot of back and forth. I'll just let you know right now. But this is going to be done with one of our patent professionals, one of our patent examiners, who is a quasi-judicial official, well versed in both the technology and the laws and rules of U.S. patent practice. We are not the U.S. Rejection Office. We are here to give you what you want because it's what we want, and that's a patent that you could take to the bank and not to the courthouse. Now, sometimes it does require some back and forth, and it doesn't always end in a U.S. patent, but we promise and pledge to work with you, particularly if you have patentable subject matter and we can find it in your application. We will help you tease that out in order to result in a U.S. patent. With that, let's jump into talking about trademarks. We are the U.S. Patent Trademark Office, after all. Now, as I like to say, some of you, and hopefully many of you, have something protectable by a patent, or you're contemplating your invention and might want to seek to protect it with a patent. Nearly all of you, and likely all of you, have something protectable by a trademark. A trademark is the indicator of the source of goods or services. So what does that mean? It is any word, name, symbol, device, or any combination thereof used to identify and distinguish goods and services and to indicate their source. Now, I saw in the chat earlier there was a question about the distinction between a trademark and a service mark, and that's a great question. Generally, we refer to all of them as trademarks. But because trademarks can be used to show the indication of the source of goods or services, sometimes people refer to those trademarks related to services as service marks. But you can also call those trademarks as well. Now, I alluded to earlier a nuance in trademark practice. So you'll see on this slide here, you'll see the TM, the SM, and the R within the circle. So trademarks, sort of like copyrights, are self-authenticating to the extent that by using a mark in commerce, you in fact have a trademark. You have what is called a common law trademark. Now, I should also say that some states have state-based trademarks. So keep in mind and look within your state. But by using a mark in commerce, you have a trademark. And that's when you would use the TM. Now, of course, we at the U.S. Patent and Trademark Office want to encourage you to federally register your mark with the U.S. Patent and Trademark Office if you plan to use your mark in interstate commerce outside of your small geographic area. Now, if you're doing something that's just with a very local footprint, you might not need to take that extra step with the federally registered trademark. However, there's this thing out there called the internet, which a lot of us are using for selling products and services. And if you're planning to do that, you are probably planning to work outside of your geographic area. So you're going to want to think about that federally registered trademark. The federally registered trademark is what is indicated by the R with the circle. So what are some of the types of trademarks? There's word marks, there's composite marks, which are words and symbols or a logo. A special form mark, meaning you've used special characters in creating your word mark. And then, of course, there can be a design mark. Now, we don't stop there, though. There are some additional non-traditional things that can be used as marks. Things such as sounds, colors, and smells. Let's take a look at some of those more specifically. Examples of trademark colors. Tiffany blue. When you get something in that special robin's egg blue box, you know that it has come from the source of Tiffany's. When the brown truck pulls out up in your neighborhood and they're delivering packages, you know it's what can Brown do for you? It is the United Parcel Service. John Deere Green, those tractors out in the field, you know when you see that green with the yellow accent that it is some type of a harvester combine that has been produced by John Deere. So in certain instances, colors can serve as the indicator of the source of goods and services. How about scents? There aren't a lot of scent trademarks, but there's a handful. And here's one that I think you'll all quickly recognize: the scent of Play-Doh. And then last but not least, how about some sound marks? The NBC chimes, the sound of Darth Vader breathing, the sound of the lightsaber. These are the indicator of the source of goods and services. Now, when you are considering selecting a trademark, we at the U.S. Patent and Trademark Office want to encourage you to select a mark which is going to be strong, which is going to be able to really last the duration of your endeavor. So we encourage you to have either a fanciful or arbitrary mark, a suggestive mark, maybe a descriptive mark will make it through, but not something that is generic. If you select a word that is generic, it in fact cannot serve as a federally registered trademark because we will not issue it as a mark. So let's say, for example, you've come up with a new dairy beverage and you want to call it milk. Unfortunately, milk is a generic term that cannot be taken from the public discourse to be used as a trademark. No, instead, we really want you to come up with fanciful or arbitrary. So what is fanciful? Fanciful is a word like Xerox, a word like Exxon. These words have no meaning outside of serving as a federally registered trademark. Now, what is arbitrary? I'll give you a great example. Apple for computer products and services. Now, yes, Apple is a real intangible thing, an apple. Go to the grocery store, pick up a nice crisp apple. But when Apple is used as a trademark to serve as the indicator of the source of IT products and services, it is a arbitrary type of trademark. That is the way we reference that type of mark. So we encourage you to have fanciful or arbitrary because they are the strongest types of mark. Now, suggestive might be something such as copper tone that suggests a quality or property of the use of the product or service. So why federally register a trademark? If they are self-authenticating by using that mark in commerce, why take the additional step and financial outlay and process to apply to the U.S. Patent and Trademark Office? Well, again, it's a little bit like the conversation Samantha had regarding copyrights. You enable yourself to have nationwide protection. It provides a constructive notice of right to use. It alerts the public to the fact that this is being used as a trademark by a particular owner, namely you. The USPTO will refuse later filed applications that are confusingly similar because that is a determination that our trademark examining attorneys make when reviewing applications that are coming in. Would there be confusion on the part of the buying public if this mark were issued as in a similar field of endeavor to an existing mark? It allows you to use the circle with the R symbol, again, putting the public on notice that you have federally registered this mark. It provides the ability to prevent the importation of infringing goods through our colleagues at the border control. Can be used as a basis for obtaining registration in a foreign country and provides statutory damages and attorney fees available in federal litigation relating to infringement. Now, the one thing I have not yet told you is the duration of a federally registered trademark. Well, this is where it gets really interesting, folks. The duration is potentially forever. Thus, why your trademark might be your most valuable form of intellectual property. If you continue to use that mark in commerce and continue to renew it with the U.S. Patent and Trademark Office on the renewal cycle, which is currently every 10 years, you could potentially have a trademark that lasts forever. Now, if you stop using your trademark, You are required to alert the U.S. Patent and Trademark Office because we want to alert the public that this is no longer a live or active mark. And we do regularly do investigations of marks on the registry to determine if there's any deadwood or marks that are not being used in commerce. Because if they're not being used in commerce, we want to release them such that others can use them. So again, trademarks can be your most valuable intellectual property asset, in part because of their duration. So let's just keep that in mind. I want to take a quick minute to do a quick case study just to show you how patents, trademarks, and copyrights can be valuable no matter what your endeavor. Now, I'm sure many of us who have tuned in today have a pet. Well, I'll tell you, Marissa Strang had a pet. And Miss Marissa Strang, when she was 8 years old, was participating in an invention competition where she had to identify a problem and come up with a solution. Her problem was that she had to wash the family dog. And when she washed the family dog, he would run through the house and get everything wet. She decided this was the problem she wanted to solve. So at 8 years old, when she was in the third grade, she became an inventor. And she received a U.S. patent, a federally registered trademark, and she created a copyrighted website. So let's just see a little bit more about Marissa. So Marissa invented a device for drawing pets, which was basically a blanket that folded out, it wrapped around the dog, velcroed up the back. There was a drawstring at the neck and a hosel where you could attach a hairdryer. And sort of like those old-fashioned hair bonnets that used to dry your hair, you could dry your pet. Marissa, as you can see here, appeared on the Jimmy Fallon Show. She received a U.S. patent. She also federally registered her trademark, the Puff and Fluff, which is the device for drawing pets, and she created a copyrighted website. Now, Marissa is now in her early 20s, living her best life, still selling her product in stores in South Florida and on the internet. So, problem solving? Yes, that's where invention comes in. Trademarks? You've got to let people know where and how to find your product. And of course, these days, everyone needs a good website. So this chart, which I know is rich with information, is just a little summary of some of the things we've talked about today. I know we haven't talked about trade secrets, but you'll see how they weave into the conversation of creating that IP portfolio. These all play hand in hand as you are creating your business endeavor. Again, whether creating a product or a service, you have things that are potentially protectable by a patent, a trademark, a copyright, and or a trade secret, building that IP portfolio. Now, I want to be sure we leave enough time for questions, but I do want to hit just a couple of resources very quickly. One of which is I would strongly encourage you to visit our website if you have not done so, particularly for those of you who are just dipping your toe in the water of intellectual property. If you go to our Learning and Resources pull-down tab, which you can see across the top toolbar here, that's where I think you're going to find some of the best information and the best place to get started. Our IP identifier tool helps you to identify what types of intellectual property you might be creating in any endeavor, whether it's something protectable by a patent or trademark, a copyright, or a trade secret. Answer 6 quick questions, and we're going to give you a little feedback on what type of intellectual property you should be looking at. We have information and resources for inventors and entrepreneurs, and it's led in a chronological fashion. This page is one of my favorites, very honestly, because it is really a one-stop shop. And that chronological fashion, to me, makes the information very digestible. We then have resources that are specific for startups. And this is where we take that inventor entrepreneur conversation to the next level and not only have USPTO resources, but some resources for outside agencies and partners as well. Now, recognizing that seeking a patent or a trademark has some complexity to it. They both involve a legal process and seeking a right from the federal government. We do have 2 great assistance centers, the Inventor Assistance Center and the Trademark Assistance Center, both of which are staffed Monday through Friday. They are there to take your phone call, they are there to take your email, and welcome engaging with you. And it doesn't matter if you filed or you're getting ready to file, or You've maybe even already got that patent or trademark in hand, and now you're asking, what now? These people are there to help you. Like this event that's being conducted today, the USPTO also offers a host of training opportunities Monday through Friday, and you can find those events on our event page on our website. It's exciting to know we also have a resource network of patent and trademark resource centers, or PTRCs, located across the nation. It's a network of over 100 libraries where there is one or more librarian gifted in teaching patent and trademark searching. Now, you're not required by law to conduct a patent or a trademark search prior to filing your application. But as I like to say, why not be a well-educated consumer? Understand what you're getting yourself into, but also understand the landscape in which you are inventing, or the landscape of the trademark you are looking to secure. Because maybe your idea is just so great, somebody else has already thought of it. Why not save yourself the financial outlay, the headache, and the heartache of discovering after filing a patent application or after filing a trademark registration that your idea is already out there? Now, for our financially under-resourced inventors and innovators, we have two great resources, one of which is law school clinics, which across the nation offer free legal services, some of which are in the area of patents, some of which are in the area of trademarks, and some facilitate assistance of both. You can find this map on our website, and you can in fact search our website for your state specifically, Louisiana, or wherever you're conducting your business, and find those resources that are in your community. Additionally, the corollary program to our law school clinics is the USPTO Patent Pro Bono program. This too helps financially under-resourced inventors to ensure that financially under-resourced inventors are not leaving inventions on the kitchen table or garage workbench because they cannot afford legal representation. So the USPTO has partnered with legal associations across the nation to offer free or reduced cost legal services. Now, you do have to apply to these programs, and generally people apply to the program that is in their geographic area. And you do have to meet certain criteria, one of which is you have to be under a certain financial cap. A second of which is you have to have more than a mere idea. You actually, in fact, have to have an invention which you can bring forward and actually start a business or grow an industry. You also have to have some skin in the game, showing that by either filing a provisional patent application or taking a course on the USPTO.gov website to show that you understand and appreciate what you are undertaking. Now, with that, like Samantha, I want to encourage you to visit us on all of our social media platforms. We're always sharing educational tips, resources, and sometimes just some really interesting, fun stories. So I hope you'll check us out on all of our social media platforms. With that, I am going to close out with an email address for my team, which is at southeast@uspto.gov. That's also our phone number where you can reach us for assistance. And I am going to shut down this slide set and turn the stage back to Margaret so that we can take any questions that are coming in from our audience today.
Thank you so much. One question we did have was, once the office is notified that a trademark is no longer being used, is it available immediately for others?
Well, that's a great question. And it is a great idea to search our trademark database, which you can do from our website, to determine if a mark is dead or alive. Those marks that are dead, you probably want to do a little investigation to see if they have recently expired or if they've been dead for a long time, because it may be that somebody has missed a payment or may try to revive a mark. So I would certainly think about enlisting the help of an IP professional, but you will be able to see on our website those that are live and those that are dead. did arguably are available for use by other individuals, but I would exercise a word of caution.
Okay, also, someone wanted to know, will the slides be provided so I can send it out to the attendees?
Certainly happy to share them with you, Margaret.
Yes,
Thank
and we'll share
you.
ours as well.
Angela, I'm not really sure. You could unmute yourself and ask your question.
Hi, thank you.
Mhm.
Elizabeth just mentioned that requirement of attendance so that we have a basic, whoever is applying for our patent or a trademark have a basic understanding. So does attendance today meet that requirement? And if so, how do we document that?
Oh, thank you for asking your question verbally, Angela. And now I see where you're going with it.
Yeah.
I mentioned with respect to being able to participate in one of the patent pro bono programs, needing to show a recognition of what you're undertaking. So no,
Yes.
your two options for showing evidence of that is again to either file your own provisional patent application without the assistance of an attorney or to take a course that is available through our website. So while this program today was very educational and informative, it doesn't meet the same requirement as the course that is on our website.
Okay. Thank you. That's what I needed to know. Yes. Thank you very much.
And also to let you guys know, I send out a weekly business events and resources email. And of course, I share the U.S. Patent and Trademark Office events that they have weekly. So you all will definitely be added to that list. So yeah, you'll know about upcoming events. Do we have any other questions? Okay, you can unmute yourself and ask your question.
Hi, thank you so much. Um, I have a question about a state level uh, trademark registration for a logo. If it is registered on the state level, am I understanding that you can put TM behind it?
That is correct. You can only use the circle with the R after having received a federal registration through the U.S. Patent and Trademark Office. The TM indicates a common law trademark or a state registered trademark. There's not an additional type of marking outside of the TM, SM, and circle with the R. There's no other indicator for state level.
Thank you so much.
Are there any other questions? Okay, I think my presenters did an awesome job today, providing us with lots of information. Thank you both, Elizabeth and Samantha, for taking your time to be with us today. Within 5 to 10 business days, this session will be added to the Office of Economic Development YouTube. Our next session is Thursday, August the 13th. And our speakers for the day will be Mr. Aaron Steele, IRS Stakeholder Liaison, and Ms. Romy Samuel. She's the City of New Orleans Collector of Revenue. Please check your emails for reminders, and I hope you all can join us again. Again, thank you all. This has been awesome. Have a great day.